objection issue?
There are still some objections. We are waiting on a Daubert witness who is maybe 10 or 15 minutes away from the courthouse. That is, of course, Mr. Shoemaker, who both created the animation and has testified about it in the past. If we can wait, we can do it now. I think it's going to be better for us to wait, but I mean, it's...
Okay. Has the state seen the new version?
Yes.
Okay. And what are your objections at this point in time?
As outlined in the supplemental motion, Your Honor, where I kind of itemized several of them.
Well, some of them were resolved.
Really, portions of one of them have been resolved. Most of the rest of them remain. As it relates specifically to D, the portion of D that indicates that the number of blows being depicted, the angles and reactions to those blows, the behavior of the figure representing the victim after the fatal gunshot was inflicted by the defendant, those have been removed. So those do not longer apply. However, the remainder of D is unaddressed. Also, as I informed Mr. O'Mara, it's difficult to tell based on objection J, what the change in version 3 from version 2 really was based on. Is it, in other words, is it based on the idea that now we are only sticking to certain testimony, whereas in deposition he testified that it was written statements, police reports, the defendant's video walkthrough, location of the shell casing, and also in-court testimony, which prompted the change from 1 to 2? Or have we now gone all the way and only using in-court testimony? I don't know. I simply don't know the nature or the basis for the change. So,
would it be helpful to the state to talk to Mr. Shoemaker when he gets here before we go into the time for a hearing, and maybe those questions will be answered, and then we can limit the scope of things?
Certainly, I'm happy to do that, Your Honor.
Okay.
I think that makes perfect sense. The question is just keeping the court here until he gets here and we do that. The only alternative would be to take this up in the morning.
I'd rather do it now.
Okay.
Okay, so what we'll do is I'll be in recess until Mr. Shoemaker gets here, and at that time, if the state and the defense will meet with Mr. Shoemaker to see if you've resolved some of your questions, and then let me know by letting the deputies know when you're ready.
Mr. God,
yeah, just a housekeeping matter, Your Honor. States 193 was a timeline of calls,
Right.
and we made some handwritten changes to it. We have since reprinted it so it doesn't look like handwriting and looks more professional. With the court's permission, and I think the defense has agreed that they are identical now, we would ask to substitute the pre-printed for the 193, the handwritten copy.
Any objections from the defense?
No.
Okay, if you want to just take the sticker off or put a new sticker on, and
You don't want it marked as a redacted and an unredacted.
because it's not redacted, it's just, it has the same information, but it's just typed differently.
So if we can just put a 193 on this one.
There is something different.
What's that? Right.
RTL.
Right, that's what we,
It was handwritten as it's supposed to be
Right.
printed, so if you want to create a new sticker or take that sticker off, it's fine.
Okay.
thank you, Judge.
So the court will be in recess until I'm told you're ready.
You have an issue about additional notice on the weather. Have you had a chance to review them?
Maybe you can review that while we're in recess. Thank you.
Your Honor,
Okay. Did y'all have an opportunity to talk?
we have talked about it. There are still concerns I think the court's going to need to resolve.
Okay.
We haven't met General Shoemaker yet. General Shoemaker, Judge Nelson.
Hello, good afternoon.
I believe that we need to have an admissibility hearing. I know the state has some objections. I guess we can identify those and then might then we'll just go forward with Mr. Shoemaker.
Even before we get to that point, Judge, part of the motion did contain a request for a Richardson hearing as it relates to the timeliness of the disclosure. And as I said, the current version of this animation was provided to me approximately 1:30, 1:45 today here in the courtroom. In addition to which, just during our consultation, I found out that the reason for the new version, which I think pages 33 and 34 of his deposition, we discussed that there weren't going to be any more, is that a couple days ago, this witness spoke to another defense expert witness and changed the animation based upon that consultation, neither of which was disclosed either by counsel or I think the other witness was deposed within the last few days as well. He didn't bother to mention that either. Mr. Shoemaker, I think his deposition was completed significantly in advance of whatever meeting they had, so I wouldn't have expected him to mention it other than, as I say, on pages 33 and 34 of his deposition, we anticipated that there would be no more of this. So I guess before we even proceed to the admissibility hearing further, I'm in the same position I was before with, again, having new information about the source of all this stuff and not having had the chance to adequately and fully explore that.
Okay, and what is it that you're requesting the court do?
As far as this goes,
You have to have some kind of a...
I do, and my request would be, again, since I'm now having to re-explore this again with a new video, I'm going to ask again for the opportunity to more fully develop that issue by continuing again the deposition of Mr. Shoemaker. And I also believe that based upon this information, the deposition of Dr. DeMaio will need to be reopened so that that issue can be addressed as well with him, because it wasn't. And so that is what I'm asking the court. I suppose I don't mind so much if the court wants to proceed at least on the foundational questions of admissibility for Daubert purposes here. Candidly, I'm assuming that for most of those criteria, the defendant will be able to meet them following this hearing. So I don't object to participating with that. However, as it relates to the addressing of the specific objections, again, I'm going to want a little more opportunity with this witness to flesh those out.
Okay, so what I'm hearing from you, Mr. Manti, and correct me if I'm wrong, that you really don't think that this is a Daubert issue, and it's more for the court to address your objections to certain aspects of this animation.
As I understand it, while I agree with the court that it is a Daubert issue, I believe, just based upon my knowledge of the witness's CV, my knowledge of the software that's used, and the deposition that's been taken so far, I believe that they will be able to satisfy the court as to the Daubert standard. So my primary objection is not to going forward on that so that we can get that out of the way and it can be of record. However, my issue is what we do beyond that. Once we've satisfied that it might be admissible for Daubert purposes or a whole other reasons, that the objections by the state that are filed here are not based upon Daubert. They're based upon other things.
Well, I was trying to make a determination if we were going to go forward with a Daubert hearing, if the state is satisfied that this animation, once the admissibility is determined in concert with your objections, then why do we need to go through and take all the testimony?
I agree with the court, and that's the reason in the objections I did not ask for a Daubert hearing. I think the case law is fairly clear that this sort of thing is going to be, and I believe the witness can testify and would satisfy the court, so I am not asking for a Daubert hearing.
Right.
But I understand why the court wanted one, and I was happy to proceed with that.
Well, I only wanted one if that was what the state was seeking, but now the state is not seeking a Daubert determination by the court, and I don't need to go forward with that part of it, but I can take, under the case, the Pierce case, there's a certain hearing that has to be held that determines whether or not this is admissible, and I'm prepared to go forward with that if you are.
Well, and that was, again, why I brought up to the court that we are now on yet another new version of the software based upon yet another conversation that wasn't covered in the deposition and has actually occurred subsequent to the deposition, and nobody told us.
So what would you like to do about that? Do you want the court to go forward with the hearing under the Pierce case, or do you want to have an opportunity to talk to Mr. Shoemaker about what your concerns are and address this in the morning? What is it that you're asking? You said you needed more time, I'm just trying
I
to
would
figure
like
out.
to reopen his deposition, not just talk to him, because I have talked to him, and based upon my conversation with him, I now have additional concerns.
He's here now?
Yes.
Do you want to take his deposition now?
I would be happy to do that, Judge.
Any objections to that? And then we'll continue this hearing at 8:30 in the morning?
That's fine. Do you want any clarity as to the points of concern, or just let it see if they open them up in a deposition?
Give him the opportunity to open it up in deposition, because it may not be an issue in the morning.
Okay.
Or it may pare down the issues that have to be determined in the morning.
Okay.
Mr.
So-
Manti said he needs to explore that issue more with Mr. Shoemaker, and he would prefer to do that by deposition, and I will afford him the opportunity to do so, especially in light of the fact that Mr. Shoemaker is here and available at this time.
Thank you, Your Honor, and again, I just got it at 1:30 today and just found out about this subsequent conversation half an hour ago.
So any objections to the court recessing for the evening, allowing the deposition to be continued of Mr. Shoemaker this evening, and being back in court at 8:30 in the morning?
No, thank you, Your Honor.
Yeah. We had another proffer at 8:30, so we'll just line them up. And you may want to deal with the jury, because we're going to need, I'm not sure the extent of the non-Daubert hearing we're going to have. The Pierce hearing, I think, is going to be also pretty easy to accomplish. I know that the state's concerns are, you have this happening, it may not be that, but that's not, I think, that's just weight, not admissibility, I think. But we can get to that, and then right after we finish with that part of it, we'll need to talk to or deal with the other proffer, which I think is going to take another 45 minutes or so for that. So I'm just thinking the jury's not, we're going to get to see the jury till,
Is that witness supposed to be testifying tomorrow? The other proffer, can we have that proffer hearing tomorrow after court?
he's not looking at me, look at me.
Subject only, of course, to how quickly things go tomorrow. We can't really predict when all of the witnesses we have planned will finish. Certainly, at the point that we have no other witnesses, we could take on that proffer and then immediately follow that with his testimony.
All right, why don't we do a wait and see in that, and we'll do this hearing tomorrow morning at 8:30. The other proffer will be
Whenever we can.
prior to the testimony. Is that acceptable to both sides?
Yes, Your Honor.
What witness are we talking about, the second one?
That would be
Dr.
Connor, Richard Connor, regarding the proffers of that
I
information.
apologize for interjecting, but I know that Dr. DeMaio, based on what we've just found out, I may need to redepose him as to that limited thing again if he's providing additional information or additional opinions that I was not aware of in the deposition that we took Saturday. So I just want to have an opportunity to depose, if necessary, Dr. DeMaio based on what we have just found out half an hour ago that occurred. Apparently, Dr. DeMaio at some point spoke to this witness, Mr. Schumacher, I believe it is. And I took his deposition Saturday, never mentioned that, so I'd like to have an opportunity to fully explore that, and I apologize, but I took his deposition
Can you
Saturday.
do that over the phone first, and then if there's a need to actually take a deposition, then you can be given the
I spoke to
opportunity?
Mr. West, and I believe Dr. DeMaio's en route, so we're going to try to do that, but
And just to clear up the issues so we know what we're talking about with Dr. DeMaio and the interaction of the two, the question is the angle of the gunshot. Dr. Bao testified as 90 degrees. Dr. DeMaio confirmed that it's 90 degrees, and then there were conversations about the distance between the skin and the clothing, which, as they took in deposition, was 2 to 4 inches. It was that very specific and quite limited fact that was communicated from Dr. DeMaio to Mr. Shoemaker. In this animation, that only shows up as how Mr. Shoemaker has Trayvon Martin over. We know, and it'll never be determined, that the shot is 90 degrees, but we don't know the exact angle of Trayvon Martin's body or of George Zimmerman's arm, but we know that. It is looking like that. That's something that goes to weight to the jury. That's the only issue that was discussed between the two. I will tell you that there was the only other information was Dr. DeMaio's knowledge of gunshot being that 2 by 2 inch stippling pattern suggests that the clothing was about 2 to 4 inches away. So we're not talking about a really precise, a detailed re-examination. what I just told you was the fact that they need to
All
talk
right,
about.
well, since you're taking Mr. Shoemaker's, continuing his deposition today, you can ask him about what information he got from Dr. DeMaio, and then you can call Dr. DeMaio on the phone and see if you need to further take his deposition, and we'll address that issue if need be.
Thank you.
Thank you, Your
All
Honor.
right, is there anything else that we need to take up before the court recesses for today?
No, thanks, Your Honor. We have a couple of matters pending we'll deal with tomorrow.
Well, if counsel will approach, I have that one question to ask you. Court is in recess. Mr. Shoemaker, if you'll please stay for your deposition until 8:30 in the morning.